from my approach as judgment of acquittal argument with case law just presented in the state and the court, and I see I'm getting some as well.
Thank you. Yes, you may.
There are a number of different issues that come to mind that needs the court's attention, and I can focus the court on some of the case law that addresses it. One is the extent to which that there is a standard for judgment of acquittal in a circumstantial evidence case. Of course, it's up to the court to a certain extent to determine whether or not there is any direct evidence of my client's guilt and direct evidence which would counter-indicate my client's self-defense that has now been properly presented, actually by his own statements, but has now presented to the jury and to this court by all of his oral and written statements that have been provided. So, firstly, the court has to make a determination whether or not there is any direct evidence that would support ill will, hatred, and spite, which is really the operative element of second-degree murder, which the state would need to prove exist in order for this matter to go forward to the jury. So as to the circumstantial evidence nature, of course, to the extent that the state intends to use circumstantial evidence to prove up their case, even, of course, at this stage of the proceedings, which is while you still have to look at the evidence that does exist in the light most favorable to the state, nonetheless, you have to look at that direct evidence in the light most favorable to the state and circumstantial evidence in the light most favorable to the state, but the same standards still apply, and that is to the extent that the state intends to use circumstantial evidence, that even in the light most favorable to the state, that circumstantial evidence still has to negate any possibility of innocence of my client. So even when we look at it under the judgment of acquittal, and I'll tell you the cases to look at in a moment, you have them in front of you. So if you were to focus on Walker versus State, cited at 957 Southern 2nd 560, a Florida Supreme Court case from 2007, that case does talk about the judgment of acquittal and says that in the case where no view which the jury may lawfully take of it favorable to the opposite party can be sustained under the law, and says in circumstantial evidence cases the judgment of acquittal is appropriate if the state fails to present evidence from which the jury can exclude every reasonable hypothesis except that of guilt. So the standard still is, to the extent that we can look at direct evidence and the court may consider the expletives that have been used as some, well, I would argue with it, but I guess the court could look at it and say the words that he used might evidence, maybe direct evidence of ill will and hatred. I would suggest that though maybe the way other people have said it or screamed it in the courtroom, the evidence that's before the court and before the jury, the way my client used it, and certainly the entire context of the way he used it in his conversation on the non-emergency call does not suggest anywhere near the level necessary for ill will, spite, and hatred. Under that suggested, if you were to even consider that direct evidence, short of that, I would suggest that there is no other direct evidence to support any contention whatsoever of second-degree murder as to the ill will, spite, and hatred argument. The circumstantial evidence, then, that may exist, and they've tried to present to you that my client is some, I'm not exactly sure what the state's case is yet, but to the extent that what they're trying to say to you is that my client was a frustrated neighborhood watch and cop wannabe and just sort of had enough and that is supported by some circumstantial evidence. I don't think that they have any direct evidence to suggest that. In effect, what they have shown is that my client has in fact been frustrated because he's called before, and on occasion the people he's called on have gotten away. However, rather than just having the huge bridge that needs to happen from that suggestion to ill will and hatred, that circumstantial evidence has to negate any hypothesis of innocence of my client, even in a judgment of acquittal standard. That being, you look at that evidence in the light most favorable to the state. It still, pursuant to Walker, has to exclude any reasonable hypothesis of innocence. And I would suggest to you that now what you have before you, what the jury has before it, is not only some reasonable hypothesis of innocence, but a very well-founded reasonable hypothesis of innocence, and that is that my client acted in self-defense. Because though you do look at all the evidence in the light most favorable to the state, you have to look at all the evidence. You can't, I don't mean to suggest this as though you don't know the standard, but you have to look at all the evidence. You can't just call out parts of evidence and say, if I take these 4 pieces of evidence and look at these in the light most favorable to the state, then I can see where judgment of acquittal should not be granted. You have to look at the entirety of the evidence that's before the court, and therefore the jury, and what is before the court is an enormous amount of information that my client acted in necessary self-defense. We will not know yet, and you don't know yet, who was screaming. And if you were to look at any evidence in the light most favorable to the state, you have equivocal statements of the only 2 people who have talked about it. You have Javarius Fulton, who says, I really want it to be him, and not sure. And then, of course, quite honestly, you have Miss Fulton, who, though she did testify, that is her son's voice, you have to take it in context. You have to understand reasonably why she would say that, how she would say that, and quite honestly also the circumstances under which it was done. That piece of evidence in and of itself, a mom saying that has to be my son who passed away, that has to be his voice because any other possibility means my son caused his own death, you could consider as evidence. However, you have to take it in context. You have to take it in the reality of the other undeniable circumstances that existed that night. And here's what existed that night in the evidence that you have to consider. My client's immediate statement to those who listened to him that he was screaming for help before he knew that that was being recorded. We can have an argument that he's this new cop wannabe who would know that it's going to be recorded, but the reality is the first person on the scene he told it to, the second person on the scene he told it to, the officer, that's Manalo and the officer, and he has the undeniable injuries that evidence nothing other than a violent attack by Trayvon Martin. There is no other reasonable hypothesis that could come from that undisputed evidence other than my client was attacked by Trayvon Martin. Some form of fashion. Is it determined quite yet how, in what precise moment? Maybe not. I would suggest that there is absolutely no evidence to contraindicate what my client now has before you and before the jury, which is that he was at the T intersection when he was attacked, approached, and then attacked by Trayvon Martin. So there's no evidence to contraindicate that. And that he was hit in the face, and there's no evidence to contraindicate that. And that it did what we all know now it did to his nose. That violent act, in and of itself, I would suggest to you, is sufficient for immediate response with deadly force. But he didn't. What we have is 40 seconds of somebody screaming. Of course, you know, my client, through his statement, said it was him screaming. 40 seconds, and receiving additional injuries consistent with, and even the state's own experts said it was consistent with my client's head being bashed against concrete, or hit, contacted, without using the emotional word of smashed, against concrete at least several times. That type of injury, in and of itself, the way it was presented by my client, that injury and the ongoing nature of that injury supports the right my client under 776 to reasonably believe that he is in fear of future bodily injury because it was ongoing. the state's own witness, Captain Carter, said one really good indication of future bodily injury is when you've already been injured and it's still ongoing. You can presume that it's going to continue to occur. And that is, in effect, why my client acted in self-defense. And there is nothing, most importantly, under Walker, there is absolutely no interpretation of the state's evidence which excludes that as a reasonable hypothesis of innocence. And if you read Walker, the very words that I said, but the whole case is quite instructive. It allows for no other determination that since my client now has presented self-defense through the state's case, but it is now affirmative evidence of why he acted and the way he acted, that since the state cannot exclude a reasonable hypothesis of innocence based upon their circumstantial evidence, that the judgment of acquittal should be granted. That's under Walker. Walker also cites Woods, and it is the Woods case, which also cites another Supreme Court case, which is Barwick, B-A-R-W-I-C-K. Barwick case is 660 Southern 2nd, 685. In 1995, Florida Supreme Court case, it also sort of began the premise in Florida law that the judgment of acquittal is appropriate if, in fact, the state fails to present evidence from which the jury can exclude every reasonable hypothesis except that of guilt. As Barwick says, Barwick again is 660 Southern 2nd, 694, Barwick tells us that you at the outset have to determine whether or not there is competent evidence from which the jury can infer guilt to the exclusion of all other inferences. I would suggest to you that this would be a textbook case. It wouldn't make it to a textbook because it is so apparent from the evidence presented at this stage of the proceedings, judgment of acquittal after the close of the state's evidence, that the inference of non-guilt is much stronger than any suggested inference of guilt. Barwick, Woods, and Walker stand without question and unassailed for this proposition and should be considered by the court as to the circumstantial evidence issue. There are other cases that I would cite for you, and you have them in front of you. Sims is a 2013 case, 110 Southern 3rd, 113, talking about the state's obligation to eliminate any reasonable hypothesis of innocence, and upheld that the judgment of acquittal in Sims should have been granted, and in fact, again, was upheld. And in that case, it also cited to law, State versus Law, LAW 559, Southern 2nd, 187. And again, all of the cases that I'm citing to you, Your Honor, you have before you, although there are some of the cases, and I believe law is one of them, since it was cited in Sims fairly well. You don't have that actual case in front of you, but the cite is quite specific. The Stee, S-T-I-E-H, versus State, 67 Southern 3rd, 275, was an interesting case for the court to consider. That's a second DCA case that's been out for a couple of years, where there was a stabbing, and the defendant argued self-defense and an ag battery, and the second DCA advised the trial court that it should have granted the motion for judgment of acquittal once the defense had provided or presented a prima facie case of self-defense. Now, I don't know if you believe that he has or not, so I have to argue both sides of it. I believe that the court should consider, and in fact should decide, that my client, through his statements over the last week and a half as they were presented, not only his statements, but all the supportive or corroborative evidence, and those are all of the witnesses, that my client has in fact presented a prima facie case of self-defense.